last segment. You are almost done with me, at least. You're stuck. But you're here voluntarily, aren't you? You're not like forced to be here. This is like, you want to do this, right? Okay, good. All right, good. This is my first time doing this, so I'm actually enjoying it more than I thought I would. So thank you all so much. I truly am. I love doing this. Okay.
That's so good. Yeah.
I try. All right. Our last 25 cases, and I'll be out of here right by 3:45, right in time. My flight's at 6, so I'm gone. I'm going home tonight. The last 25 cases focus on the Bill of Rights, which are the first 10 amendments to the Constitution. We will focus on the freedom of speech, freedom of religion, focus on the Second Amendment, and focus on the Takings Clause of the Fifth Amendment. And then you're done with me. Okay? So let's start with the freedom of speech. Okay? The First Amendment provides that Congress shall make no law abridging freedom of speech. Okay? What exactly is the freedom of speech? Well, the Constitution doesn't tell us much. Does that mean speaking orally? Does that mean writing? Does that mean singing? Does that mean painting? Does that mean photography? Does that mean making a movie? Is speech including burning a flag? Does speech include burning a cross? Does speech include violent video games? Does speech include videos of animal fighting, dog fighting? Does speech include slander and defamation? Does speech include contributing money to political campaigns? Expression. Does speech include opposing the war? Does speech include telling people to resist a military draft? Does speech include pornography? Obscenity?
What about the American football governing?
Does speech include getting on your knee
That.
during the national anthem? Thank you. One more. Right? Does speech include burning the American flag? Forget protesting the pledge, just burn the flag. Is flag burning a thing in your country? People do that?
It's in Mexico it's prohibited. It's banned.
Well, here it's no longer banned, people stop doing it, right? They only do it when it's a crime, and when you're allowed to, they don't do it anymore. All right? So our study of the First Amendment starts during World War I, the Great War. And in America, as in most countries, there was a military draft during the war, where men were required to register and serve in the military. And a lot of these boys went home and they never came back. They were killed in service. In America, there was a lot of opposition to the war. And many of those who opposed the war were socialists, right? This was around the same time as the Russian Revolution, and communism was spreading throughout the globe. So there were a series of cases decided in 1919, the same year. Schenck, Debs, and Abrams. This, by the way, is Eugene Debs. You know the name. He was a very prominent socialist. He ran for president like 5 times. Never won, but he kept running. No, but he ran for president. He was a socialist. He was a socialist, ran for president 5 times. Okay? These people were thrown in jail because they spoke critically of the government. Their offense was they criticized the war. They criticized the draft. They told people, don't go to the war. They encouraged people who work in factories to go on strike. People who made war materials to go on strike. And in Schenck, Debs, and Abrams, all 3 of those cases, the court upheld the convictions. And they explained there's a test that if your speech creates a clear and present danger, right? If your speech has a tendency to create problems, the government can prohibit it. So if you were telling people, don't go fight in the draft, don't go fight in the war, you were impeding, you're obstructing the war effort. Couldn't do that. If you were telling people who work in a missile factory to go on strike, you were impeding the war effort. So the court upheld these prosecutions. Now, this is no longer good law. right? We no longer have the sort of clear and present danger test. But these are the earlier cases where the court upheld restrictions on speech. These people were thrown in jail for handing out pamphlets and giving speeches, right? Those are not good cases. The next two cases, Gitlow and Stromberg, were important because they involve state laws, right? The first one begins, Congress shall make no law abridging freedom of speech. Congress. What about the states? Well, we studied in Cruikshank, this was the case where they burned the building and people were burned alive, right? That the Bill of Rights does not limit the states. In Gitlow and in Stromberg, the court went the other direction. And Gitlow and Stromberg recognized that now, after the 14th Amendment was ratified, the states are protected, right? Why? The word liberty is in the Due Process Clause, and the court recognized the word liberty includes the Bill of Rights. So one of the liberties that people cannot be deprived is the right of free speech. So as a result, today, virtually the entirety of the Bill of Rights, almost all of it, now applies equally to the federal government and to the state government, right? That the state cannot censor your speech, that the rules are just the same for the feds and the states. Okay? Any question on those old cases? Okay, the next three cases ask a question. When is conduct speech, right? I am talking to all of you right now. There is no question that I'm engaging in speech, right? I'm speaking. What if I do something else? What if I wave a red flag around? A red, Soviet Union flag, like a red Soviet Union flag. Am I engaging in speech? Maybe, maybe not. These cases ask specifically, when is conduct speech? So what were the facts of O'Brien? O'Brien came around in the 1960s during Vietnam. Notice all these cases during war. It's not a coincidence. During the Vietnam, the Americans had a draft, right? Where men between the ages of 18 and 30, whatever the age was, were required to register for the military, right? And when you registered for the draft, you got a little card, a little piece of cardboard, which said, I am registered for the draft. It became a very popular symbol of protest to publicly burn your draft card, where they would go to a public place and they would light the draft card on fire. And they did this as a way to protest the Vietnam War and get attention. The federal government prosecuted O'Brien for burning his draft card. Right? What happened? The court said, you can prosecute him. Why? This was a government record. And the court said the government has a right to manage their own programs, and if you destroy this paperwork, the draft can't operate. There were no computers back then. If you wanted to check if someone was eligible for the draft, you asked them to produce their card. If they can't produce their card, you know who they are. So in the years before computer, this was a way to keep track of who people were and where they lived. And destroying these cards obstructed the military effort. Now, did Congress throw this guy in jail because he destroyed a record? Of course not. Right? This was means to punish dissent, right? Punish protest. But the court said there was a very good reason to have it, and even though there was some effect on free speech, the government interest justified the law.
What about the conduct of Muhammad Ali? I know he refused to go to a march.
Yeah.
And he went to a trial, the persecutors.
Yeah.
Did something.
Yeah, he resisted the draft. That's not a speech issue. This is specifically by First Amendment. But there were conscientious objectors, people whose religion did not permit them to fight, and there were a lot of cases where they'd be excused from the draft. The courts were skeptical. Some religions like Amish or Quaker, they're pacifists. It was very common during the war that people became Amish because, I'm now Quaker, right? They would suddenly discover the virtues of pacifism, and there were debates whether this was genuine or not, right? They didn't doubt that the religion was pacifist, but they doubted these people were actually believing it. They said, you're just doing this to get out of the draft. So there were a lot of cases about that. Thank you. Yes?
Sorry, I may not have understood well, but in this case, in 81, they didn't talk about speech at all because they weren't on the side of saying that the draft belongs to the government or they haven't had an interest.
Yes.
The
court acknowledged that preventing the destruction of the draft card, that law would impact free speech. But the government had a greater interest in managing the draft, and they needed this paperwork to manage the draft. Exactly.
But it did not determine that that act was also a speech.
But it was, right? They said the act of burning the card was expressive.
Okay.
Because it was expressive, it was protection by the First Amendment, but the state had a big interest to override the speech. The second case is called Texas versus Johnson. See a lot of Texas stuff, right? This involved flag burning. At the 1984 Republican Convention, a guy named Johnson, Gregory Johnson, burned an American flag as a civil protest. He was an anarchist, you know the type, long beard, scruffy kind of guy. He burned the flag. You have in every country, I'm sure. Yeah. He burned an American flag. He was prosecuted for burning a flag. And the Supreme Court, in a 5-4 decision, said you cannot do that. Burning the flag is a form of political dissent, and you cannot punish him based on the content of his message, right? For example, let's say that someone takes a flag, gives it a hug, and waves it around, is very proud. Is the state going to arrest him? No, because he's being patriotic. Now the same guy takes a flag, douses it in kerosene, and lights it on fire. Okay, then you go to jail. The state cannot single out unpopular viewpoints for punishment. In other words, the state cannot discriminate in the content of one's speech, right? They can't punish people because it's unpatriotic, but reward patriotic speech. You cannot single out unpopular speech. Any questions on that one? Yeah, that's Texas versus Johnson, 1989.
And President Trump, when the players of NFL then they need in protest, does he can refuse to receive the White House like a political act?
Okay, yeah. So only a few minutes. So the NFL issue, right, is private. And the National Football League can regulate their players however they want. So there's no First Amendment right for the NFL. Now, if you're a high school student at a public school, and you choose to take a knee during the national anthem, you cannot be punished. Students cannot be forced to say the Pledge of Allegiance, for example. Do you have this Pledge of Allegiance in your country where at the start of school every day you say a pledge to the flag?
No.
We do. And there's I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, liberty and justice. One nation under God, indivisible, with liberty and justice for all. Every American student says at the beginning of class, but you can't be forced to say it. Students can opt out. In fact, in Texas, you actually have a pledge for the Texas flag as well. Yeah, I actually don't remember it by heart. I'm a bad Texan. My daughters are natural born Texan. She'll learn it, but I don't know it. Students can't be forced to say the pledge. They can't be forced to salute the flag. They cannot be forced to stand during the anthem at a public institution. Right? Cannot. They cannot be forced. There was actually a case in which the Supreme Court said that a student can be forced to say the pledge, and then about 8 years later they reversed it. Right? So the Supreme Court reversed itself and said, no. The Pledge of Allegiance has to be voluntary. For example, Jehovah's Witness, in their religion, they do not salute anything. It's a graven image. And to salute a flag is like saluting an idol. So they will not do it, and that's one group that's usually bringing this sort of litigation.
Therefore, if it is a private institution, they can rule on?
Yes, if it's a private school, they can do whatever they want.
For example, but the NFL can rule on that one?
Yeah, the NFL could say as a matter of collective bargaining that their players must stand during the anthem. That's perfectly fine. That's a labor law issue. That's not First Amendment. That's whatever collective bargaining agreement they reach with a union. Yeah, I think the NBA does have in their collective bargaining agreement that you have to stand during the national anthem. I think that, but the NFL did not have that in their collective bargaining agreement. That's just a matter of labor law. That's not about the Constitution. Okay. Anything else on Texas versus Johnson, burning the flag? Yeah.
What about if you are representing the country?
Like Olympics?
Yeah.
What's her name? The soccer player.
That's true.
Rationale. Yeah. Yeah, I'm not sure. I don't know if the U.S. women's national team has anything in their contract about standing for the flag. I'm not sure.
But it would be something.
But assuming it's contractual, the state cannot make them. There's possibly some sort of contractual obligation that I'm not sure. Yeah.
Maybe I did not understand this clearly, but all the rights that are granted by the Constitution cannot be enforced against private.
That's exactly right. Private organization.
Private organization could do whatever they want.
Unless there's a statute. So for example, Congress says private businesses cannot discriminate on basis of race, right? That's a matter of statutory law, not constitutional law. There's lots of statutes restricting what corporations can do, but it's not in the Constitution for statutes. Makes sense, yeah? Not everything's constitutional law. Thankfully, I have way too much to do. There's only so much I can do. Statutes, I don't care with. Let other people deal with them. I don't care. It's not my thing.
Alright, just for the sake of clarity, then in that case, the court ruled in favor of Johnson, in spite of the ban existing in Texas.
Yes, the Texas ban was unconstitutional. Exactly. And in fact, after Texas versus Johnson, a lot of people wanted to amend the Constitution to ban flag burning. It didn't get a vote, but it was actually pretty popular. So we did not have a flag burning amendment. People considered it, but didn't go. All right, the next one is a little bit more dicey. RAV versus City of St. Paul. Why RAV? He's a juvenile. And when you have a juvenile, you don't put his name in the case, you use his initials. So his initial, I don't know what his name was, but his initials are RAV. He was a teenager. What did he do? He took a chair, he broke the legs apart, he made a cross out of it. He brought the cross to the yard of an African-American family and lit it on fire. Yeah. Teenager. He was charged with what you would call hate speech, which I'm sure in many of your countries exists. That this was meant to incite and antagonize based on race. Supreme Court reversed conviction 9-0. We do not have a law that permits hate speech violations. We don't have that in our tradition. Even if speech is based on racism or bigotry, whatever word you want to use, it's still speech. And to prohibit it is based on its content, or maybe its viewpoint, and we don't allow content-based restrictions. Now, if you engage in a violent act, let's say you kill someone with a racist intent, you can punish them moreover, or a hate crime. But mere speech, shouting a slur or burning a cross, cannot be prosecuted. Maybe as a threat, you can threaten someone. You can't threaten someone. But merely burning the cross is not enough.
So the KKK would be a threat?
Well, there was another case where the Klan burned a cross in someone's yard as a way to threaten him. You can't do that. But that's a matter of intent or mens rea, right? These kids were just being jerks.
Yeah.
I mean, I don't want to put it lightly, but there was not the requisites for a threat. A threat needs a certain level, right? They were just being assholes, right? It didn't meet the level of a threat, right? Yeah.
And what if the speech encourages people to make violent acts?
Incitement, right? So there's a very famous case, which is not on this list, but I'll mention, called Brandenburg versus Ohio. Brandenburg versus Ohio, 1968, give or take. And this case involved the Ku Klux Klan. And you had the leader of the Klan say, next month we're going to march in Washington and we're going to do lots of racist things. And the court said you can't punish him for that because it wasn't imminent, right? It was, we'll go next month. Unless you are inciting imminent violence, like right now. Like, I'm saying, let's go burn down the Capitol. Let's go right now. Let's go. I'm like, whipping you up. Let's burn this down, right? I might be able to be prosecuted. But unless there's imminent violence, you cannot punish the speech. That's very different from what you have in your countries. Very different. In this regard, the United States is quite unique in a lot of regards. But this is one regard where we have a very unique regime. Okay. You always just think, I always think you're raising your hand.
I'm just
It's okay.
playing around with the
It's
pen.
okay.
Sorry, it's confusing.
It's
I
okay.
apologize.
I always would tend to scan your hand. Yeah.
Like, for example, when you talk about imminence, does that mean,
Now.
I mean, what does that mean?
Now.
Because,
Now.
but,
Minutes.
yeah, but do you mean the activity of, for example, the actual march, or actually committing the crime?
The violence, illegal activity. Yeah, if you encourage people to peacefully march, that's fine. But you say, let's go burn this down, let's go riot, let's go be, that's something else, right? You have to encourage imminent unlawful conduct.
Okay.
Right? Because if I say, let's go peacefully protest right now, that's fine. But it's like, let's go riot and loot and burn stuff down. That's a different story. you know, I gave an example a couple years ago, but say, you know, there have been court cases where, for example, a person was shot by the police, and then the jury acquits the police officer, and then a riot forms afterwards, right? And what someone says, this is unjust, let's go burn down the police station right now, okay? That would be a case where you could arrest me for that speech. That might be an example, because it's like passionate right now, emotional. But those cases are rare. You don't get many prosecutions for incitement of violence, which it doesn't happen very often because it's so hard to prove.
What about terrorism?
Yeah, so material support for terrorism is a gray area in free speech. And there was a case maybe about 7 or 8 years ago in which various groups in the United States wanted to provide support for the Tamil Tigers, for Indonesia, I think, right? And they weren't actually engaging in terrorism, but they were providing legal support for them. And the Supreme Court said that that's not good. You can't support terrorism. So there's some fuzzy lines on material support for terrorism, which aren't entirely consistent with Brandenburg. It's also overseas. It's a little messy. I love your questions, but they make me start breaking my very neat narrative here. This is like a straight line, and then it's like I have to go zig and zag. I can zig, zag. Okay. So in RAV, all 9 justices agreed that the prosecution for burning the cross was unconstitutional. That the hate crime, the hate speech law was unconstitutional. Some justices thought it was based on content. Others thought it was based on viewpoint discrimination, but all 9 agreed it was unconstitutional. So unless burning a cross becomes a threat or something more incitement to violence.
Or for being in private property?
Okay, good point, right? They could have simply prosecuted the teenager for trespass, right? They were trespassing on the guy's lawn. Why did they use that charge? They wanted to test out the hate speech statute, right? In fact, the majority said because there was another charge you could have brought, this was especially inappropriate. You could have used a lesser charge. But they want to punish the speech, not merely the act of trespass. A very good point. Yeah?
Yes, I guess that in all those cases, there were maybe many dissenting opinions, right? Or
on REV?
Yes. Well, in general terms, in the
this was 9-0.
to the freedom of which one? Sorry.
REV was 9-0, unanimous.
9-0.
Unanimous. The flag brand was 5-4. It was close. I think O'Brien was either 8-1 or 7-2. I can't remember, but it was pretty lopsided. So you surprised by that?
Yes.
Why?
No. I mean, I thought that maybe.
Well, REV, all 9 justices agreed that the prosecution was wrong. They disagreed on the rationale. So some justices thought that these sorts of laws are never permissible, and others thought that maybe it might be permissible in some cases, but not here. So they sort of disagree on the rationale, but all 9 agreed the law went too far.
Okay.
See, my neat narrative breaks down good questions. What else? What else? Okay. All right, let's go on. All right, the next round of cases are probably completely foreign to you, right? I think this is a distinctly American jurisprudence. Money at stake. My God, what are you talking about, Latin? Right? Here's the thinking. If this thing is not stable, if I want to support a cause, let's just say save the whales, right? How can I save the whales? Right? Well, I can get in a boat and clean up garbage at the beach. Right? I can protest and support environmental legislation, or I can maybe make signs saying save the whales, or I can support politicians who favor the whales. I can back groups that support politicians that favor the whales. I can make contributions to politicians who favor the whales. I can make advertisements that criticize politicians who hate whales. So it's not that insane when you actually think about it, right? There are different ways of affecting policy. And one way is with your wallet. And to actually contribute money to candidates or provide money for advertisements for or against certain issues. So I think the United States is fairly unique in that the First Amendment, our free speech clause, limits the regulation of campaign finance. But this area, my friends, is messy. And we have three cases, Buckley versus Leo, McConnell versus the Federal Election Commission, and Citizens United versus the Federal Election Commission, decided about 40 years apart, that reach very different results. Let's start with Buckley. In Buckley, the Supreme Court drew a distinction. They said Congress can put limits on money given directly to a candidate, right? So if I want to write a check to Donald Trump or Mitch McConnell or Nancy Pelosi or anyone else, there's a limit of how much money I can give them, right? Why? There's a risk of corruption. If I can write unlimited checks to a candidate, people might think, wow, he has her in his pocket, right? And even if there's no actual corruption, there is the appearance of corruption, right? It might appear corrupt. So the court said that contributions to candidates can be limited to avoid the appearance of corruption. Okay, everyone with me? But what about if I give money to an organization and that organization wants to run advertisements that either support or criticize the candidate? These are not called contributions. They're called expenditures, right? It's a term that doesn't make much sense. You have contributions, which is money right to a candidate, and you have expenditures, which is money given to these outside groups. The court said that Congress cannot limit the expenditures because that's how we express ourselves, right? Save the whales, kill the whales, whatever your view is, right? So you have this weird division that makes no sense to anyone else, right? You can't give the money to the politician directly, but you can give the money to a group that supports the politician, as long as you're not coordinated. So you have outside groups running these advertisements. You ever watch American TV? This ad was paid for by whatever, right? As long as they announce who they are, basically unlimited money can go to these other groups. Okay? That's Buckley. Very, very complicated, long decision.
So you can control the donations directly to
Contributions.
the contributions.
Yeah.
Then directly to the politicians, but not for the groups that supports them.
Yeah.
Or against them.
Exactly right. Makes sense, right?
Yeah.
Okay, but the next case involved a different issue, right? The next case put more limitations on money that can be spent before an election, right? For example, it said if you want to air a commercial on broadcast TV or radio, you can't do it right before the election, right? In other words, fine, all this money is going to politics, but you can't use it to influence the election, right? So you can't, for example, run a TV advertisement right before the election. So McConnell was in 2003 and said that was fine, that Congress could limit these sorts of broadcasts right before the election. They are paid for by corporate funds. Okay? McConnell decided in 2003. Justice O'Connor was the controlling vote in that case. She retired in 2005. Justice O'Connor was replaced by Justice Alito, who was far more conservative. In 2010, the court reversed McConnell. And the court held that the freedom of speech does not allow the prohibition of such advertisements. And the court had a very important example. What happens if instead of publishing a commercial on TV before the election, we publish a book? We publish a book paid for with corporate funds. Could the government prohibit the publication of a book before the election? And initially the government said, yes, we could ban a book. Let me tell you something, my friends. If you ever argue in American court, and your argument is you can ban a book, you're going to lose. So the case was re-argued, and the government said, no, well, you can't ban a book, but you can ban a commercial on TV or a movie. And the court said that's not a good line to draw. That you can express yourself through a movie or a book or a pamphlet, and you cannot ban those, even if corporate funds are paying for it. So under the law now, after Citizens United, corporate funds can be used to run advertisements at any point. And we're in this weird world where you cannot contribute unlimited money to a candidate directly, but you can contribute virtually unlimited money to outside groups. and that's the world we live in. So long as there's no corruption or the appearance of corruption. Yeah.
Is this related to what they call a super PAC?
Yes, yes. So PAC stands for Political Action Committee, and Super PAC is like an even bigger political action committee. These are groups that can aggregate large amounts of money and use them to support or oppose candidates or issues or causes. The one requirement is they have to disclose who they are. So in any commercial, this ad was paid for by Save the Whale PAC, whatever it is. And they have to disclose their donors as well, who gave money to them. But once they have the money, they can use it in just any fashion. They can't coordinate with the candidate, though. That's one limitation, right? They can't coordinate. The candidate can't tell them, oh, here, run this and that. It has to be separation, but it's very small separation. They're all friends.
Can you repeat PAC mean political act?
PAC, P-A-C, Political Action Committee.
Action.
Action Committee.
So in this case 8 to 6, this was overturned, this limit on broadcasting.
I'm sorry?
In this case 8 to 6, this limit on broadcasting was overturned?
McConnell, yeah. In Citizens United, much of McConnell was overruled. Not the entire thing, but a lot of it. The portion on broadcast for the election. It's called electioneering, if you want the word. In fact, what were the facts in Citizens United? This was a case that arose in 2008 when Hillary Clinton ran for president the first time. And they published this movie called Hillary the Movie, which was very critical of Hillary Clinton. And the government said, you cannot air this movie 60 days before the election. And they wanted to run this movie online, on demand, and they couldn't do it. And the court said, you have the right to publish this movie before the election. Now, by the time this case was decided, Hillary already lost the election with Obama. But they wanted to run it before the election, but they weren't able to. All right. Any other questions on campaign finance, money, and speech? Very controversial element of American
They
law.
won't be able to run the movie before the